It's now up to a federal appeals court as to whether Illinois' law prohibiting concealed carry on mass transit is constitutional after a district court said it was. Quick segment here on some of the oral arguments from yesterday in the Seventh Circuit U.S. Court of Appeals in the Schoenthal case. This is a case that was filed back in 2022. Several plaintiffs suing the state of Illinois and Cook County over prohibitions of allowing concealed carry firearms onto mass transits. And in the district court, a judge declared that it was unconstitutional, only applied to the plaintiffs in the case, not a broad declaration that it's unconstitutional. So after that happened, you had the state defendants in this case essentially file a motion and saying that after the judge's ruling, there was a shooting on the Chicago subway where 2 people were killed, and the judge had to bring the attorneys in, chastise them, and continued on with the case, giving it to the appeals court after declaring it was unconstitutional. So yesterday was the hearing. When exactly the appeals court's going to rule on this, it's a great question. But if you were able to tune in to the U.S. Seventh Circuit Court of Appeals yesterday on their YouTube channel, you heard some of those arguments. I'm just going to go through some of them here really quick. This is Alex Hemmer. He is the Deputy Solicitor General for the state of Illinois. He talked about why he thinks that the appeals court needs to reverse the district court's finding that prohibiting concealed carry on mass transit is unconstitutional. And let's hear it.
Is directly from a tradition of restricting access to firearms that are loaded and unsecured in passenger railroads in the 19th century, which itself descends from a tradition of restricting access to firearms in crowded spaces. Second, the restriction is analogous to those locations in which the Supreme Court has held that states have broad authority to restrict access to firearms. Like these sensitive places, public transit systems are owned and operated by the government. They're characterized by crowded and confined spaces, and they're full of vulnerable individuals. Upholding the district court would require breaking from the Second Circuit's opinion in Antonyuk and the Ninth Circuit's opinion in Wolford. The court should instead follow those decisions and reverse the judgment below.
So again, Hemmer saying that the 2 main arguments they have is answering the historical analog question and the societal concern question, right? So ultimately saying that, hey, it was the 19th century private railroad rules that say, hey, you can't bring firearms onto the railways. And then going further saying that there's sensitive places like courts and legislatures and such, where there's a lot of people around, and a train is very similar. There's a lot of people around. He goes on to further talk more about the issues of why they say the lower court's decision was wrong and the appeals court needs to reverse it.
Sites of government regulation because of their nature, schools, courthouses, legislative assemblies, polling places, and as we explain in the brief, public transit shares many common characteristics with those locations, including that the government kind of has a proprietary interest in maintaining order and ensuring safety in those spaces, both because that's its role and because it wants to kind of avoid the liability that occurs when there are gunfire incidents in public transit.
So Hemmer, being for the state, laying out those arguments for the appeals court. Then you had the plaintiffs in this case. John Ohlendorf is the attorney for Schoenthal et al., and he said, listen, the 19th century, it's not when we're supposed to be looking for analogous laws. It's supposed to be from 1791, when the Second Amendment was ratified.
When the Second Amendment was ratified in 1791, which this court has said is the critical year for determining the amendment's historical meaning, defendants have pointed to no firearms restrictions specific to public transit during that era. Instead, they rely on the tradition of restricting firearms in so-called sensitive places. But Bruin identified only 3 such sensitive places at the founding: legislative assemblies, courthouses, and polling places, and none of those are remotely analogous to public transit facilities.
You get Ollendorf continuing on with his arguments, again highlighting that the standing they have because of the threat of criminal prosecution and a variety of other things, arguing that the district court got it right, saying prohibiting concealed carry on mass transit is unconstitutional.
Here's another way to look at it. If one of my clients had been prosecuted, had actually, instead of bringing this pre-enforcement challenge, had carried his firearm onto the L, and had been prosecuted under Section 65A8 for doing that, there is no question that he would have had standing to raise the Second Amendment as a defense to that prosecution.
More from Ollendorf.
Yeah, my primary argument to you is we have an injury in fact. It's the one that we pleaded. It's the one that the district court found. We face a threat of criminal prosecution. His judgment does away with that injury in fact. That is
only from this statute, though. It sounds like you're saying that we have to look at the alleged harm just in terms of the one statute, not the potential prosecution based on the other one.
That, I think, is the injury that we pleaded, and it clearly a threat of criminal prosecution is an injury in fact that suffices for Article 3 purposes. And when it's looked at.
So the arguments they're having there about jurisdiction and standing, and do they actually have standing to bring this case even though they haven't been charged with something? Clearly that's something that the appeals court's going to have to tackle when it comes to that particular legal question about standing. But Ollendorf continues on, wrapping things up.
It has to be 1791 or 1868 as to both. And it's a very odd reading that would say that the federal government, which has been bound by the Second Amendment since 1791, somehow had the meaning transformed in 1868 so that it's now bound by a different meaning. And the Supreme Court has always looked, when analyzing Bill of Rights restrictions as applied to the federal government, to 1791. So I think it follows from those two strands of Supreme Court jurisprudence, which Bruin left undisturbed, that the key point is 1791, and so railroad regulations that don't come onto the scene until 1875 are just too late.
So that's John Ollendorf. He was the attorney for the plaintiffs. You then have in these hearings, you've got the people who are appealing, making their plea to the judges, 3-judge panel. Then you get those who won in the lower district making their plea to the judges. And then you get those who are appealing, again, the state and county, having a rebuttal. Here's Alex Hemmer during the rebuttal.
Or I think there's a really strong argument that the 1800s, for the reasons that you set out, Judge St. Eve, is a highly probative kind of time period, especially for state firearm restrictions, given that our assent to the Second Amendment was kind of effectuated through the 14th Amendment during the Reconstruction era.
So that's the argument. I think we're going to hear more about that type of argument in the future as they get their things together, and it's an argument that is going to have to be used not just with the prohibition of concealed carry on mass transit. It's also going to be the prohibition of 170 plus semi-automatic firearms and magazines over certain capacities. That's still in the appeals court. There's a lot going on there, and that's why I think it's important you wake up with us each and every weekday morning. I'll give you a rundown of what's going on in the Second Amendment space within Illinois. Get headlines at thecentersquare.com. I'm Greg Bishop. You'll find tons more at thecentersquare.com.